Welcome to the Shriram IAS Unacademy platform. Today I am going to talk about public interest litigation. So, public interest litigation is an offshoot of the 1980s. During the emergency, the Indian judiciary did not come to the rescue of the citizens. In the sense, the powers that be during the emergency had suspended fundamental rights, and the citizens had no effective remedy against that suspension of fundamental rights under Article 32, because Article 32 had been suspended. So the citizens virtually had no right to seek remedy. But 9 high courts in the country ruled in favor of the citizen. They said the citizens still had the right to remedy, legal remedies against suspension of fundamental rights, but the Supreme, when the appeal went to the Supreme Court set up a constitutional bench of 5 judges in the ADM Jabalpur versus Shivkant Shukla case. It is a notorious case in the sense it was considered as a black moment in the history of the Indian Supreme Court, because 4 of the 5 judges had justified the suspension of fundamental rights, saying that it was in accordance with Article 21, in accordance with the law laid down according to the due process. So, only one among the judges, Justice H.R. Khanna, he dissented from the majority and said there are certain natural rights which could not be suspended, and therefore citizens had a right to remedy. So, that being the case, the ADM Jabalpur versus Shivkant Shukla was considered an anathema by the Supreme Court itself for a long time. It was not relied upon by subsequent benches, and it was formally overruled only recently in 2017 in the Puttaswamy case, which, as you all know, the right to privacy was declared a fundamental right by a 9 judges bench. Now let's come back to the period in which the public interest litigation was born. So, in order to understand the origins of public interest litigation, we should understand what are the compulsions of the Indian Supreme Court to come out with anything like this. So, in order to erase the impression that the Supreme Court sided with the government during the emergency, the judges of the Supreme Court took conscious efforts to refurbish its image, the image of the Supreme Court, and also regain the lost credibility, the public confidence which was lost during the emergency in the role of the judiciary, in the effectiveness of the judiciary, in the power of the judiciary. So they tried to make the decisions of the Supreme Court closer to the people, and many of the people's problems were taken up suo motu. So what exactly is the public interest litigation? As the very word suggests, public interest litigation revolves around public interest. So there may be situations when a certain class of people are not able to come to the court, right? And there may be situations when certain sections of society are illiterate because of their illiteracy and the inability to mobilize among themselves, organize themselves and come before the court. So some other person who is knowledgeable enough about the court's procedures take up their cause and come to the court to plead on their behalf. That is public interest litigation, and the court consciously did away with the need for locus standi. So if at all there is has to be a dispute, as you know, before the court every dispute is considered as adversarial. There is a winner, there is a loser. So when a dispute comes up before the court considers whether the litigant, the petitioner, has a locus standi. Locus standi, in the sense, the person suffered any personal injury in order to justify the litigation. So the preliminary question, if it is answered in the affirmative, only then the court goes on to the next step. But in the case of public interest litigation, the necessity for locus standi is waived by the court deliberately in order to encourage the public interest litigant to come to the court, to plead on behalf of the other persons who are unable to come to the court. So that is the way the public interest litigation has to be understood. And if you take the first case, this is generally considered the first case, the Husain-Ara Khatun versus State of Bihar. So in this case, what happened? In this case, the rights of the prisoners are involved. So the court came to the rescue of the rights of the prisoners against torture, against their exploitation and things like that. So that's how it came to the prominence. The second case is equally important, Anil Yadav versus State of Bihar. So what happened in that case? In that case, as you might have, those who have studied the contemporary Indian history, especially after post-independence, you would have known about the Bhagalpur blindings case. What is the case about? 33 prisoners, they were under trials, innocent people. So they were blinded by the policemen. Acid was put in their eyes, they were blinded. So the Supreme Court was shocked by this story published in the newspapers. So they immediately, asked the prisoners, the case against the prisoners to be quashed, and they were brought to Delhi for treatment, to be given free by the state. That is Anil Yadav versus State of Bihar. So these are two broad examples wherein the court came to the rescue of the under trial prisoners and also the prisoners who were being subjected to torture in the Husain-Ara Khatun case. So victims of, it all started like this, victims of torture, then you have the pollution, environmental pollution, traffic pollution. So the citizen files a petition and the court asks the state to explain how it can be remedied. So here there is no adversarial concept. Public interest litigation is deliberately said there is no, it's not adversarial. So very often you find that the court asks the state to come up with solutions which are in public interest, because these are not adversarial. So the normal jurisprudence, the normal rules of legal procedure should not be a handicap for resolution of the grievances of the citizens who approach the court through the PIL route. So right to speedy trial is another right. So you find that there are so many rights which are born out of PILs in the post-80s, and they were declared part of Article 21. Article 21, if you read, it's very simple. It says you have a right to life and liberty, right, and it cannot be taken away except according to the procedure established by law. But this right kept on expanding. So this court said you have a right to life and liberty, also includes the right to speedy trial, right to dignity, right to clean environment, right to health, and so on and so forth, education, right to education, which became part of Article 21. Children between 6 and 14, they had to be given free education, right to education. It's also a fundamental duty on the part of parents to provide, parents and guardians, to provide education, opportunities for education for the children between 6 and 14. So you have a bonded labor case. Bonded labor was existing earlier. But only in 1976, the legislation came into being against bonded labor. But still the bonded labor cases came to the court, and the court passed many directions to free bonded labor and ensure their welfare through court's directives. So what the court did, court not only gave directions, but the court started maintaining, also monitoring the progress of the compliance by the authorities, right? So PILs, on the one hand, they try to ensure the court's intervention in cases where there was complete absence of executive action, and there was a legislative void which the court filled in. For instance, the Vishaka case, sexual harassment in workplace. So there was no law, but the court issued a series of directions to ensure that women felt safe in the workplace, which held the ground till 2013 when the act was passed. So this is the whole objective of the judicial activism, we call it. In the sense, judicial activism is relevant because it fills the gap between the legislative vacuum and the law whenever it is passed. So these directions are replaced by the formal law. So in the beginning, it all started like this, the bonded labor case and right to education, environment, etc., speedy trial, right to speedy trial, etc. So in the 90s, you find there is a shift taking place in the PIL movement. The courts started, expanding the horizons of the PIL, and it became more and more political. In the sense, the PIL was invoked to protest, to ensure accountability when when there was a political stalemate, when there was an uncertainty about the mandate, electoral mandate. So you have the famous Bommai case, where the court laid down elaborate rules regarding who should be invited in the case of fractured verdicts after the elections. What should be done? Who should be invited first? Who should be invited next? If that first person is not able to prove majority. So this sort of thing. So the court started laying down guidelines on various things, even political matters, because the court primarily said if it is if a subject is political, it's not as if the court's hands are tied. Court can inquire into even thick political questions and find solutions if there are legal solutions possible. So you have basically the broad history of this public interest litigation, and if you find that there is in the beginning, even the postcards were accepted as petitions. So it's called epistolary jurisdiction. Epistolary. Jurisdiction. So the ordinary people write postcards, petitions, inviting the attention of the judges to their problems. So that is what the court did. Okay, we will screen all these postcards and petitions. If there is a subject matter which falls under the PIL, it can be taken up by the court. So what are the guidelines which the courts adopted? So if you look at the Supreme Court's website, there are guidelines for PILs. What do these guidelines say? The guidelines say that PIL should be entertained only if the subject matter pertains to certain categories. What are those categories? The categories are, number one, the exploitation of labor. if there are child victims. If there is exploitation of women. Right. So, like that, certain categories were identified and then they were put as guidelines for screening the PAL petitions, whether they actually deserve. Because very often you have cases before the court where the court says, looks at the petitioner's arguments and then the court says, your hands are not clean, so we are not going to entertain you under the public PAL jurisdiction. So, apart from that, there are certain exclusions also. The court says, okay, these categories, the following categories cannot be accepted under the PAL jurisdiction. What are those categories? Rent matter, rent disputes, right? Then service matters, we can't accept this. And you have admission matters in the educational institutions, we can't accept this under PAL. So whether a particular case falls under PAL, the court has devised this mechanism to determine in terms of various categories. So yesterday, if you find the case before the Supreme Court where the court approved the High Court's, Orissa High Court's quashing of land acquisition by a prominent business conglomerate, Vedanta, where it was told that the petitioners lacked public interest. So, but the High Court said, no, do not lack public interest because they were owners of land who were deprived of their lands, agricultural lands, by the acquisition. And many of them could not come to the court. Only some came, some did not come. Some got compensation, some did not get compensation. But the court said, under PAL jurisdiction, we declare that those who did not approach us also deserve to be compensated, and they also had right to be represented by those who came to us. Therefore, their access to justice cannot be closed under this PAL jurisdiction. So they are genuine petitioners because they had the goal of justice to be delivered by the court and against injustice perpetrated in terms of land acquisition, forcible land acquisition without sufficient public interest. So whether there is public interest or not, the court examines the arguments during the hearing and comes to a conclusion. So roughly this is the broad picture of public interest litigation. It's an evolving phenomenon in the sense there have been criticisms that the court has been encouraging public interest litigation, and there are also arguments that court has not really entertained PALs on genuine matters, saying that it doesn't qualify to be PAL. So there are both pros and cons of this, whether the guidelines need to be fine-tuned in order to cater to the really needy people, whether the shift that has taken place in the 90s and 2000s, which enabled the privileged sections, the middle classes, to make use of the PAL in a more effective manner at the cost of the interest of the poor and the underprivileged. Whether this process can be reversed is growing, is a debate which is before the academics and the policymakers, and the debate goes on, and we'll have to wait and watch how the PAL movement can benefit the really underprivileged, the poor sections, and the illiterate and the marginalized people, so to speak, for whom the initial emphasis was laid in the PAL. So friends, that's topic today. Thank you so much.